Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi everybody, welcome to the February 2022 edition of the Third Fridays podcast. We had last month's edition, and one of my good friends who isn't really in the industry, but I guess likes me a lot, follows the podcast and listened to the episode and said that it had too much of an NPR feel. And I think that maybe it was because I was doing it by myself. So we're back to the guest format. I have one of my favorite guys in the office. Ian Haberstro is here as a guest the second time, right? Ian, did you guest once last year? I think you did.
Yes, I did. Actually, we discussed IMEs as well in that podcast, I believe it's too.
Oh, right. Okay, great. So Ian is here today to talk about IMEs again. But more specifically, when we think that an IME should not be obtained by an employer or carrier in a New York workers' compensation claim. Now, Ian and I have talked for months and months over these types of opportunities because we've gone back and forth over the strengths and weaknesses of each position. But essentially, that's what this podcast is, right? All the shop talk that we do in the office, giving all of you an inside track and a fly-on-the-wall approach to how we do things here. So let's get into it. I guess before that, though, IME stands for Independent Medical Examination. I just have this weird bugaboo, this like pet peeve when people say IME exam. Right?
Because it's repetitive.
It's in there. It's almost like when people say like ATM machine, right? It's just, I don't know. It's weird, but whatever. We broke it down into different scenarios where you think that clients should not be getting IMEs.
Correct.
Is there any? I guess it may seem obvious, but in all of these categories, what does the client really face when they do get an IME?
So you and I, as we've discussed, there is a general trend, especially with the law judges, and I think it is also almost encouraged by some claimants attorneys to get an IME when there is somewhat of a suspect idea as to whether or not a claimant has actually suffered an injury as a result of their work accident, right? And the trend is that basically the law judge wants the carrier to go out and get an IME, as does the claimant's attorney, in the hopes that the IME will concede causal relationship. And then what does a law judge do? Basically, you go back to the hearing, and all of a sudden they'll say, because your IME conceded, I'm going to establish it. And we say, no, hold on, judge. There's some questions regarding the actual accident history given to our IME, or there may be some issues that need to be developed. A law judge will pretty much almost always overlook that and say, you can note your objection, but I'm going to establish the claim, right?
So essentially like using the report against us.
Exactly,
right?
Yes.
Even though it's not the only tenet to compensability, right? We may have other defenses involved.
Yes.
It's this... I was about to say time-honored, but I don't think it's honorable at all when law judges do this, that, a doctor that's designed to rebut the findings of a treating physician concedes something and we're hit with it, right? Looking at an IME as an independent physician and using that to add exposure to a claim has been the real issue. And, sometimes without the proper advice, clients will look at a notice of decision, they'll see that an IME is directed, and they'll just get the IME. So we've looked at a couple of instances where it may not be the best thing to do. Now, we have eliminated some of the more obvious ones. For example, let's say you're getting an IME for schedule loss of use, but a treating doctor finds an opinion that doesn't move any net award to the claimant. We're not going to go into that. We're not going to go into claims where maybe you're just making a coverage defense or an employer-employee relationship defense. If you're saying that those defenses are your main defenses and they're pretty strong, why spend the money on an independent medical examination? So we won't go over those ones. Those are a little bit more obvious, and I think that clients really are aware of those types of scenarios. But we broke it down to 3 categories, and I think the first one is the one that really touched on this type of conversation that we've been having. And it really goes to what I deem a specificity failure. So Ian, what does that mean? And what are some examples of when an IME should not be obtained due to a specificity failure?
So the big one, obviously, are OD/NCR claims where the treating doctor has failed to give any distinctive features of the claimant's employment to explain how the claimant actually developed the alleged occupational disease. Another would be instances where, say, a claimant is alleging a consequential injury after the claim is already established, but nowhere in the treating doctor's report does he establish or explain how the consequential injury developed as a result of the established injuries. And then there's also the ANCA repetitive stress claims, where many times the doctor will simply say the claimant has pain as a result of their work, but does not give any actual specific explanation as to how that pain or alleged injury developed related to the work activities. So those are the 3 main areas where we see a treating doctor fail to give specifics in their what ultimately will be found to be the PFME report by the law judge. And in those instances, when there are no specifics in the treating doctor's reports, it's my position that we should not be getting an IME because the treating doctor has already failed to meet the burden of proof. But this is obviously the basis of our podcast.
Yeah, so let's pick one of them, right? So which one do you want to start with where we'll rehash exactly what you mean by that?
Okay, so obviously controverted OD/NCR claims are the issue that kind of developed our discussion. Or
what's an example of a controverted OD/NCR claim?
So you'll have let's pick a somebody that works at a like in a warehouse, right? And they're basically they have a physical job, but they're on a forklift a large part of the day. And you'll get a report, and it'll simply say that the claimant engages in a lot of bending, lifting, and walking activities, and now all of a sudden has developed bilateral knee injuries, bilateral shoulder injuries. But there's nothing distinctive about bending, lifting. When a doctor gives a very generalized explanation for how these alleged injuries developed that is not distinct to the claimant's employment, through case law, we can have the case disallowed. But if we go and get an IME, and then that IME says, and many times the IME will actually be given a much more detailed history than what the treating doctor received. So then all of a sudden, the IME gets a more detailed history, concedes causal relationship, and now we're fighting an uphill battle.
Okay, so this one, does kind of ring true for me. I'm not going to disagree with you all the time. Okay. So we have, the bending, the walking, the lifting, and I think what goes to this is activities that can be repeated elsewhere, right? Like a person bends, lifts, walks, sits, and stands at home.
Yep.
So when the claimant goes into his or her own doctor and says, this is what I do, and then just says work, naturally the PFME doctor is going to say, well, I guess if that's what you do at work, then that's what caused this.
Right.
But if there's nothing distinctive about the claimant's job, in your case, working that forklift, for example, he's on the forklift 4 hours a day. And during those 4 hours, right, He is sitting in a position where the seat makes him arch forward or arch back, and because of that, right? Like, those are distinctive things about the claimant's job duties.
Correct.
That essentially put the onus on us to refute. But what you're saying is, if there's nothing about the specificity of the job, that we should not get an IME to refute causal relationship. You'd rather cross-examine the doctor.
Exactly, yes.
Okay. Now, what's the difference between that and a traumatic repetitive stress claim?
So an ANCI repetitive stress claim is generally, so say on one day a claimant engages in some type of repetitive activity, say they were just hammering away at a wall and breaking up a wall, but their general job duties had nothing to do with that. And so on one day they were doing a repetitive activity, that they developed pain. They didn't actually have an accident, but it's given ANCR because it's a specific date. It's not developed over time. There's no actual accident, but the claimant did develop pain as a result of this repetitive activity on a specific date. Now, to differentiate that from an ODNCR claim is essentially the same phrase we used before, a distinctive feature of the claimant's employment that caused pain over a period of time, right? So it's not a specific day that it happened. It would be something that developed over weeks, months, a year, and it's distinct to the claimant's employment, right? It would be a specific job duty, just much like you said, driving a forklift, they're sitting on the forklift, they're tweaking their back as a result of, shifting the seat, and that develops over time. That would be an occupational disease claim, as opposed to, say, in that same exact instance, say it was a non-forklift driver that got on a forklift one day, and as a result of, let's just say, moving the seat or whatever they had to do on that specific day, that would be an ANCR repetitive stress claim broadly. I mean, that would be probably not necessarily compensable, but you get the distinction, right? As opposed to...
So you're hammering, maybe put it in timeline terms, you can be hammering away on a particular day and you know that you got hurt from that day, or you could be hammering for 30 years as part of your job.
Right.
And you don't know which day really caused the injury. That's an occupational exposure claim.
Exactly, yes.
The traumatic repetitive stress is when you can really narrow it down to this particular day.
Correct.
So if we use that hammering concept, right, the activity of hammering away on a particular day, what type of medical report are you looking at where you're going to think about not getting an IME?
So you're saying, okay, well, let's just say that we have a carpenter, right? And the carpenter fills out a C3. Will lead into the medical report. And what does the C3 say? Maybe sometimes it'll just simply say developed arm pain as a result of repetitive work activities. Won't give us any distinctive features. That's on the C3.
Developed arm pain because of working?
As a result of work activities, right? A very vague C3.
Okay. The
claimant goes to the treating doctor. Treating doctor receives basically the same history. He knows the claimant's a carpenter, but obviously he does not receive any specifics regarding the claimant's job. Now, all of a sudden, I have a report in my hands that I really like, right? I'm looking at a treating doctor's report that says the claimant was a carpenter for 25 years, developed arm pain as a result of his work activities. It says nothing in that report about what his actual work activities are. So in my mind, I'm looking at that report and on cross-examination, I'm going to be like, okay, so doctor, you said it was work-related, but you did not document any specific job features in this report that caused the actual, arm injuries. Did you receive an actual job description from the claimant? No, I didn't. Maybe he was a supervisor. Maybe he hasn't been doing anything for a very long period of time. And all of a sudden, I now have a treating doctor report that I can pick apart. So that, to me, is the type of treating doctor report, PFME report, that I like to see. As soon as I see something that's very vague from a treating doctor saying the claimant developed pain as a result of his work activities over 25 years, this is the type of report that I can pick apart on cross-examination.
So essentially with that one, the reasons are a little bit similar, right? Because, in the first example, we're talking about the specificity of the duties that cause an injury over time. And in the repetitive stress traumatic claim, where you're locking it into a particular day, you're still saying the doctor didn't document something about the claimant's job duties. Like he's just a carpenter who now has an injury to his arm from overuse, right?
Yes, if it just says overuse, then that's actually a report that I would be happy to see from a treating doctor, because I already know he's not giving specifics.
And again, to frame it back to our clients, right? If we get the IME in that case, what you worry about is what?
That the claimant is going to give a more specific history to the IME.
See, now why would he give a more specific history to the IME?
So he's probably going to speak to his attorney prior, and the attorney is going to advise him to give the IME specifics regarding his work activities, because the claimant's attorneys also know the legal standard for...
because the claimant's attorneys want the IME to concede to get an easy one.
Exactly.
So the attorney tells the claimant to be more specific, whereas you're saying maybe the claimant's attorney is not as helpful with the claimant in pursuing something with a treating doctor?
Well, they also know that the PFME standard is very low.
Okay. All right, so those are two options where maybe the treating doctor doesn't provide specifics about what the claimant is doing or his job, right?
Right.
Now, this third option that you talked about are consequential injuries. What is an example of a consequential injury?
So the biggest one we will almost always see will be a claimant suffers a left knee injury, and then as a result of an altered gait, allegedly develops a right knee injury, even though when we get the MRI back, it'll say that he has degenerative changes in his knee, in his right knee, and that would be the most simple, straightforward way to establish a consequential injury. Would be something like that, where the claimant says, I had pain in my left knee, I had surgery, therefore I had an altered gait, and all of a sudden, due to my altered gait, I developed more pain or increased pain in my right knee, and then all of a sudden, the treating doctor's report comes back and says, now the claimant has developed a consequential injury in his right knee due to the altered gait. We go to the hearing, PFME is found. Now, in that instance, we may have to get an IME, but there are instances where that necessarily the treating doctor doesn't give us those specifics.
So let's then talk about the report, because we want to educate clients on what the reports should say before they get the IME, right? So what does a consequential report look like that causes you to think, I don't think I should be getting an IME?
Right. So many times you'll be reviewing a treating doctor report. It'll say that let's just go with the knee example. Claimant has knee pain now in the right knee, and then at the very bottom on the report, it will say something to the effect that we are now attempting to get the right knee included in this claim as a consequential injury, but does not give any specifics as to how that consequential injury developed. At that point, the law judge is going to find PFME.
So mainly you're saying the report's going to say the claimant now has a consequential right knee injury without
giving any specifics as to how it developed.
Okay. So why would cross-examination, what are you going to use in cross-examination there without an IME? Because what clients look at is, if there is an injury, then I want my doctor to look at it. But explain it a little bit more about what you're going to do in cross-examination to supplement the reason why an IME should not be procured.
So sticking with the knee example, let's say this treating doctor has examined the claimant 4 or 5 times before he documents that the claimant has right knee pain, right? I'm going to look at those prior reports, and if they make no mention of an altered gait, then all of a sudden I have a pretty good defense that the claimant did not have an altered gait that would explain the consequential knee complaints, right? So if there's no documentation in the prior exams leading up to that, and then in the PFME exam, there's no explanation as to how the consequential injury developed, then I'm going to be able to kind of pick that apart on cross-examination. Whereas, like we've said on the other examples, right, if he goes to the IME and says, all of a sudden he tells the IME, as a result of an altered gait, I developed knee pain Then the IME says, well, there's nothing else to explain it. The claimant has pre-existing degenerative changes in the knee that could have been exacerbated by the altered gait, and I'm going to find consequential relationship.
Okay, so I'm not as with you there, because I think it is very easy for a claimant's doctor or treating doctor to say because this then that, right? With a consequential injury, usually, and if we look at a crystal ball, how do I think these things come to fruition? I think what happens is the claimant tells his or her attorney that, my right knee's been bothering me too. So what does the claimant's attorney say to that claimant in that situation?
Go tell your treating doctor and have him give you an explanation as to why you developed that pain. And then what is the workers' compensation treating doctor going to say? He's going to say that it is related to your work-related left knee injury as a result of...
And would that be enough?
For PFME or for establishment? It's definitely enough for PFME.
Right.
And
that's what I want, that right there, that small pause where you're thinking about whether it's good enough for causal relationship, because it can't be a situation where we look at a consequential report and we automatically think no IME, right? Because there's no description. It's a very, very hard undertaking to make that a bulletproof statement, because as soon as you pause and think to yourself, well, is it enough for causal relationship? You might wind up needing that IME, right? If you're not fully sure. We talked about those first two examples where there's no specificity. Now we have a consequential injury for an already established claim. And I think once we feel like we're thinking about it, I don't want to rush to judgment and say no IME. Is that fair?
True. And also I think we have to take into consideration the MRI findings, right? If we know, say the MRI has already been performed on the consequential claim site, and we already know that there are at least degenerative findings, there's evidence of arthritis, there's evidence of tears, we know that that knee has an injury, and most likely pre-existing, right? Depending on the age of the case. So we know that the IME is going to have to at least agree that there is some type of injury. Then it's just going to come down to his opinion as to whether or not it developed as a result of a consequence to the established left knee injury, right?
Okay.
So, and you and I have said this before, there typically needs to be something else to explain the claimant's complaints other than the compensatory injury, right? And if that doesn't exist, many times the IME will simply say, well, there's nothing else. There may be pre-existing findings, but they could have been exacerbated, and therefore I believe the new pain is a result or as a consequence of the established left knee injury.
So in that case, I could see, right, where if there's no connection, right, it's another specificity failure, there's at least a discussion. I'm not fully on board with saying no IME for consequential injuries, because usually, if I say right now I fell on my left knee,
yep,
that altered gait would have to be so bad, right? You better have a cane, you better have had maybe even surgery, you better have limped across, to the doctor's appointment, right? You better not be able to stand, right? For that altered gait to be truly sufficient to cause a right knee injury. Usually what happens, if you're really feeling right knee pain, you might actually have a prior right knee injury that you're not telling everybody about. And if there's a potential other source for an injury, I still may want to get an IME, because I can tell the IME doctor, look at the records from this prior right knee injury.
Oh, definitely. Okay, so under those circumstances, if we have evidence of a pre-existing right knee injury, then definitely that is a very appropriate time to get an IME to comment on that, to say, can you please give us a formal opinion as to whether or not the current right knee complaints are a result of a consequential injury, or are they pre-existing and are all the findings attributable to the pre-existing injury? That I agree with you 100% on.
Okay, so let's move on from specificity failure to another type of situation, right? You mentioned multiple accident histories. So explain why, or explain a type of case where multiple accident histories would exist and why you would not want to get an IME.
So when I look through a file, if it's a controverted file, and I'll take a look at the hospital records. If we have those, I'll look at the C3. I will look at the initial treating doctor records, and sometimes there will be completely different histories, right? The hospital records, which we don't always get, will say the injury happened at home. I mean, that would be a home run right there. But let's just say it doesn't say it happened at home, but it happened on his way to work. And then his C3 says it happened at work. And then the first medical says, gives a completely different accident history, but it occurred at work. So all of a sudden there are a bunch of red flags, right? I'm looking at this file and I'm like, this claimant is not giving a consistent history. So when I see 2, 3, 4 different histories in a file, I'm already thinking I can pick this claimant apart when I take his testimony, right? And so my fear in getting an IME would be that the claimant goes, and many times the IMEs will actually look, and we will say, please look at these records. Is there a consistent history? And they'll say, there is not a consistent history. There were some distinctions between the accident histories given, but based on the history given to me by the claimant, if that history is correct, I'm going to find a causal relationship for the injuries. Whereas I feel that if I had just been able to go to the trial without having an IME concede causal relationship and cross-examine the treating doctor, I'm much more likely to win and get that case disallowed based on credibility issues with the claimant.
Here's where I might disagree there. Well, not might. I'm going to disagree here. If you have multiple accident histories, instead of having the doctor comment on causal relationship, can't I ask the doctor to answer whether or not the multiple accident histories confuse whether any injuries are related to one, both, or neither? Couldn't I do that?
You definitely could. I think the issue would be on cross-examination of the IME. You may run into difficulties there, right? The claimant's attorney will say, well, this is the actual history that was given to us in our C3. Could that have caused the knee injury or the work-related accident, or the work-related injury? And an IME will say, well, it's possible, right? Anything's possible, but it is possible.
I'm okay with that.
Okay.
I think I'm okay with that. If you ask generalized hypothetical questions to an expert witness during a deposition, if they give me an answer to say that, yeah, that's possible, I'm going to be arguing to the judge, like, is mere possibility the standard for causal relationship? No. It has to be a reasonable probability. And for a concession of possibility to be used as the way to establish the claim, I'm actually looking at that as the evidence that the judge acted incorrectly on appeal.
Right. I guess it just comes down to what your preferences are, right? For me, I just love to pick apart a claimant on cross-examination when I'm doing the trial.
But why can't you still do that with an IME? Right? Because if the IMEs ask a question, it says, please review the hospital records. The claimant reported this accident history.
But do the IMEs always answer our questions and do exactly what we ask them to answer?
No, but does anyone? Right?
No.
In any situation? I think, that's where I differ with the strategy, because if we're worried about, a possible result from someone that doesn't follow the process, it's just tough to change that process, because there are IME doctors, many of them, that do follow the process, that they answer the questions correctly, right? They examine the correct body parts. Are there IME doctors that hurt us by not following the rules? Yes. But you know what? Those doctors get siphoned out of panels, right? They don't get the same level of referrals for exams if they can't listen to directions. And ultimately speaking, if it happened all the time, I think I would be more on board with this. But if there are multiple accident histories, I might be more inclined to tell an IME doctor, look at this accident history. is this the same or different as what the claimant is telling you today?
Right.
And then look at this accident history. Is this the same or different as what the claimant's telling you today? The claimant's not going to go into the IME doctor and give two different histories. He or she's going to give one.
Right.
So if I ask both of those questions, I'm going to get something good for one of them, right? And if the IME doctor comes back and ruins my life with a bad report, well, you know what? Sometimes you just chalk it up to that, right? It's a bad report, but unless we're going in there saying, you know what, there's only one IME doctor in this region, in this time frame, and all of his or her reports are terrible. Then I might say to you, you know what, this doctor has bad experience with us. He or she gives bad reports on this type of issue. Let's run away from this doctor. But it's can you at least see that?
I think there's credence to what you're saying. I'm not obviously. This is sort of a case-by-case analysis, right? Because how often do you really get three different accident histories in a controverted claim? It probably happens maybe 25% of the time, if I'm being generous. I'm not sure. But when I see them, I love those cases. And it's just my general feeling is, I don't want the IME to shoot me in the foot.
Sure. I get that. I think that there's just some ways to really look at it. But that's what we do here, right? We're not going to just take a situation and then create one outcome for all of those situations, right?
Definitely not. Yep, I agree.
So, multiple histories and causes, that was your second example. And the third example that you provided was when a records review would be better than a physical IME. So, what's an example of that scenario coming to play?
So one that we've discussed is when a claimant has already undergone surgery to the claim body part. So sometimes I'll go to the hearings and the claimant's attorney will say, well, we would ask you to find PFME for such and such body part. And then we look through and we find out the claimant's already had surgery of that body part, right? So I'll tell the judge, obviously the claimant's body part's already been caught up in surgery. What is the purpose of having an in-person IME when the claimant has already had surgery? Obviously, there's some type of injury to that body part. Preferably, I will tell the judge, I'll say, listen, a record review would be more appropriate here to review the prior records before the surgery. And in some instances, and I think this is a general trend that is not necessarily correct, but law judges will say an in-person IME is more credible than a records review.
Generally speaking, yes.
But in this circumstance, say the claimant has already had surgery to the newly claimed body part, to me, it seems to make more logical sense for the IME just to perform a records review of all the treatment records prior to the surgery, because we already know that the claimant's body part is probably still in pain from the surgery. Why would we have the IME look at it? And many times they go to the IME and what do they say? The claimant was in too much pain, I couldn't examine the body part, right? Post-surgery.
Yeah, so it's an interesting dilemma, right? Because you want the IME doctor to determine whether there's a disability to the new body part, whether it's related to our initial accident. And, it was something that, did raise some eyebrows when you talked about this. The claimant having an extensive treatment modality to this body part before they are raising it at the compensation board level, which is very interesting too, because what would really move or encourage a claimant to get a surgery on a body part that hasn't already been paid for yet by the compensation carrier? Because a lot of times the compensation doctors don't want to go forward with a surgery until they know it's being paid by our client, right? So to me, it's very interesting to see like what type of case is happening where a claimant's bypassing the whole my right knee hurts. I go to my attorney. I go to my doctor. He or she is going to get surgery on this body part before bringing it to a judge. That to me is a very, very interesting red flag in general, right?
Right.
So it does give you some ammo there, because to me, when that happens, something else is going on that has nothing to do with the IME, that we should be focusing our efforts away from what an IME is going to say Because even if the IME looks at it and says, you just had surgery, so there's a disability there, I don't want that, so I agree with you, but I think it's the bigger picture is, why is this happening? So I think it's just a movement of our investment from an IME into somewhere else. The other, when you brought this up, the one thing I do love about records reviews is for pain management and opioid use. Mm-hmm. I don't want a physical pain management IME. There are too many factors at play. One, cost, right? It's more expensive for a pain management physical IME, especially given the fact if you're going to have them comment on medications, you might be giving them so many different records like that, maybe an orthopedic IME doesn't need to see, right? The other thing is attendance. You have to rely on the claimant to show up, right? Even when directed, even though it's in statute that they have to do it or they risk getting their benefits taken away, it's something that is relying on an adverse party.
Yep.
Right? And 3, we're not looking for this report to talk about an injury, a disability, the relationship. Yep. I'm trying to get this doctor to say, is this too much? Is this opioid medication too much? And 9 times out of 10, it is. That's why we have an epidemic in this country with opioids. Why else would you need someone to really see a claimant to see whether it's affecting him? Really, you just need to look at the records. Are the right pain thresholds being looked at? Is the right morphine equivalent dose being discussed? And even looking at the board's non-acute pain guidelines, right? Is it within those guidelines? That doesn't require a physical exam. Do you agree?
Yes, definitely. Obviously. And I think the last thing is the proper medication that is being prescribed, is it appropriate for the actual injuries that the claimant allegedly is being diagnosed with, right?
Because you don't need to see the claimant to make that opinion.
Exactly, yes.
So pain management IMEs for that purpose, that's one of when you brought this topic up, that's the first thing I thought of, right? Pain management record reviews for opioid discussion, medication weaning should always go through a records review. It's not as costly. You're not depending on an adverse party to show up, and the opinion actually doesn't need to rely on a physical exam.
Right.
So there's so many different types of cases that we've talked about today that we actually created the 3 categories for this, Ian. I know that we may disagree about it, but I think that's really the nature of this, right? A case isn't just a case. There's so many different layers as to why you may need one, why you may not.
Right.
And that's really how we form our litigation opinions. Here at Lois, we're not 30 to 40 attorneys with the same opinions about everything, because it's not possible. First of all, right? We can train on basics and what the law says,
right,
but interpreting a case to that law takes some actual skill and differentiation between attorneys. I think that's necessary. I think that's needed. I also think since we're moving to a more specialized area where we can match attorneys' skill sets with a particular client's needs, that type of thing will shine through. You start to see what goals are being set for the attorney and the handling team. I think it's more likely that the differentiation is okay. What do you think?
I completely agree with you.
So any final thoughts other than no IMEs to our clients here today?
No, but thank you for having me on. Obviously these are fun to do, so I appreciate you asking me or inviting me to come and do this.
Yeah. I like it. You have so much experience in this field. Ian here actually is really making some dents in our culture. So I would be remiss if I didn't end by having you not talk about our Challenge Coin program. So I know I'm springing this on you a little bit.
A little bit, yes.
Well, what exactly are we trying to accomplish with the Challenge Coin program?
We want to acknowledge attorneys for doing exemplary work. Basically, obviously, we want it to have a significant value. We don't want it to be a cheap thing to win. But when attorneys are getting significant wins on files, I'm not sure if you want me to go into specifics or not,
But just the nature of the program, right? They get a big win on a file. What is the program doing for them?
So basically, we're going to be monitoring what we categorize as wins for each attorney. And once they get a specific number of wins, then they get recognition by earning a challenge coin. This idea actually came out of the military. It was actually one of my friends that was in the Army, and I was at his house, and I said, "What are all these cool little things?" And he said, "You win these for completing challenges. That's why they're called a challenge coin." So then I spoke to you guys, and everybody seemed to be on board, and I actually think it's a very positive thing. People like to be recognized, right? So we're going to recognize the positive wins that our attorneys are getting, and they will be earning challenge coins as a result.
So you heard it here, guys. To all of our clients and the prospects out there, we're not doing this, just for, getting the disallowance. The disallowance or the fraud win or the big outcome really means something to us too, and I think that really puts us in line with what our clients' goals are. So Ian, thank you for coming on. To everybody still listening, I know we're on minute 41. This is Christian Cison signing off and reminding you to defend from day one.